at prayer number 12, His Excellency sought a declaration does issue that Kithure Kindiki is disqualified under Article 10 and 72 of the Constitution due to unresolved concerns from his tenure as Cabinet Secretary for the Interior and National Administration, during which Kenya endured gross violation of human rights. He also sought a declaration does issue that the National Assembly violated Articles 124 sub-Article 4 and Article 149 sub-Article 1, Section 6 of the Public Appointments Parliamentary Approval Act, Cap 7F, and Standing Order 45 in the method it adopted to approve Kithure Kindiki's nomination as Deputy President. He also sought a declaration that Kithure Kindiki was illegally appointed and procedurally cleared and unlawfully approved as nominee for Deputy President in violation of Articles 1, Article 10, Article 8, Article 118, Article 124, Article 137, Article 148, Article 149, and Article 250 of the Constitution, so that his appointment, clearance, and approval for that position is null and void. At prayer 15, he sought a declaration that the petitioner suffered harm and is therefore entitled to constitutional damages as compensation for the violations against him in terms of general damages, punitive and aggravated damages, security to be specified at the hearing, special damages under Gazette Notice number 10346 of 2023 for loss of 1, salary, 2, official transport and other prevailing transport policy for 35 months, medical cover and benefits detailed to be supplied, airtime, gratuity, and annual salary for 5 years. He calculated those sums and gave the figures. At prayer number 16, His Excellency sought pension and other benefits under the Retired Benefits Deputy President and Designated State Officers Act, Chapter 197B of the Laws of Kenya, being a monthly pension equal to 80% of the first petitioner's last monthly salary while in office. 2, a lump sum payment on retirement calculated as a sum equal to 1 year's salary paid for each term served in office. 3, 2 saloon vehicles of an engine capacity not exceeding 2,000 cc, which shall be replaceable once every 4 years. 4, 1 4-wheel drive vehicle of an engine capacity not exceeding 3,000 cc, which shall be replaceable once every 4 years. 5, a fuel allowance equal to 15% of the current monthly salary of the office holder. 6, full medical and hospital cover, providing for local and overseas treatment with a reputable insurance company for the first petitioner, the first petitioner's spouse, and the first petitioner's child who is below 18 years or is under 25 years of age and is undergoing a course of full-time education, and in the case of a female child, is not married or is not cohabiting with any person. 7, 2 drivers. 8, 1 personal assistant. 9, 1 accountant. 10, 1 secretary. 11, 2 housekeepers. 12, 2 senior support staff. 13, 2 cooks. 14, 2 gardeners. 15, 2 cleaners. 16, armed security guards, who shall be provided on the request of the first petitioner. 17, diplomatic passport for the first petitioner and his spouse. And 18, office and office equipment. 19, maintenance expense for the vehicles provided. 20, access to the VIP lounge.
When on the 4th of June, the said hearing aborted, we filed an urgent application before the Court of Appeal. CO application number 291, E291 of 2026. I also wrote an email letter to the Chief Justice as the head of the judiciary to bring into her attention the precipitate injury and ruinous violation of the petitioner's right to be heard before you render yourselves in this petition. Accordingly, the Court of Appeal certified that application is urgent. This morning, I served on everyone, including all the parties that are before you now. That application relates to the Court of Appeal's jurisdiction under Article 165(3), and therefore, in deference to the authority of the Court of Appeal, the matter being sub judice in the Court of Appeal, to arrest the delivery of a judgment, so that then a judgment can be rendered that is encompassing that petition and the consolidated petitions. I had, in deference to Section 20, subsection 1H of the High Court Administration and Organization Act, informed the Deputy Registrar of this court that application pertains to the arrest of the delivery of your judgment. And the Honorable Deputy Registrar then alerted me, asked me if I had communicated that to everybody, and I did. And therefore, in deference to the equivalent of the least pendants rule, that application being alive before the Court of Appeal, that this Honorable Court then defers the delivery of the judgment. My lords, as I close, my lady, the right to be heard, being enshrined in Article 25C of the Constitution, is non-abrogable. It cannot be abridged. But if this judgment is rendered, and peradventure, you find, as indeed you would find, that in Petition E586 of 2024, that there was no impeachment, the constitutional threshold was never met, and then you grant that petition, you nullify the impeachment, you render the decision according to the pleas of the petitioner in the amended petition, then your lordships, my lady, if peradventure you were to dismiss the petitions, hearing, it would be very embarrassing. So I suggest, in deference to that constitutional authority of the Court of Appeal, that you defer the rendering of this judgment. We can be heard tomorrow because we filed some submissions ready for the 4th of June in that E586. And then the ship can sail. You can render a judgment whether to dismiss or grant. Thank you.
Do you have an order from the Court of Appeal on this issue?
The Court of Appeal, as a matter of judicial notice, my learned friends will be aware, has the way of disposing of any matter.
I don't think we are ready for argument. I've asked, do you have an order from the Court of Appeal stopping or arresting these judgments?
As we speak right now, no, because the order of business...
You have answered me. You have answered me.
May I finish,
Judge? You have answered me, and I have accepted that answer. I will now ask some of the parties here to respond to that.
May I finish before they respond? Just for good order. My lords and my lady, we do not in the list, I do not in the list, want to bring any theatrics or sabotage the administration of justice before you. What has provoked this particular move to the Court of Appeal is the aborting of the hearing on the 4th of June 2026. And so that my learned friends can respond. On the 7th of May, before you, learned Senior Counsel Professor Agido Mugai gave me the podium so that then you could address everybody in E586. On that day, you gave, in the presence of everybody here, the 4th of June as a hearing date. So that as they address that, it is common ground that that petition was to be heard before the date to render the judgment was given. Thank you, Your Lordships. And thank you for giving me this opportunity.
Mr. Kinyanjui, this is the brief ruling on that matter. First of all, we want to note for record that the matter you are referring to is not before this court either by way of a mention or a hearing or a judgment. Indeed, it is not before us, and we are not able to take notes on that matter. Secondly, because many people here may not know where you are coming from, you yourself sought to be deconsolidated in that matter, and we gave you the orders the way you wanted them. You took yourself away from these petitions. We have made a decision on that. You will not misrepresent facts. Listen, I'm making a ruling on this matter. The matter is not before us. The Court of Appeal has had or has cited that matter. If they wanted to stop us, we would drop our pens. Give us a court order from the Court of Appeal, then we'll drop our pen. We don't have anything like that. Lastly, we gave directions the last time we were having this matter. We said that your matter will be mentioned after today's ruling. And for record, and this is the last comment we're making on this issue, your matter is coming for a mention on 18th of June, 2026. Parties before the court, are you ready to proceed?
Thank you very much, Your Lordship.